Are we done here?
No, you don't understand, ma'am. You don't understand.
Are we done here? Are we done here?
Perjury
here?
Is
do not insult my intelligence.
You have to
do not insult my intelligence.
You have to lay your.
Please do not insult my intelligence.
It's a false statement made on
Are we done here? Are we done here? Yes,
that is not what I said.
I said
that. No, I didn't. You
yes,
said
you
that.
Did. You stated
I said that circuit.
You stated that the criminal. You stated that.
I never said that.
What you're about to see sounds fake, but it's very real. A woman walks into court attempting to sue a man she recently went on a single date with, for more than $10,000. Her reason? Emotional distress. Yes, over one date. This hearing instantly spirals into one of those moments that makes you wonder how it even reached a courtroom in the first place. The judge wastes no time cutting through the noise and grounding things back in reality. Emotional distress claims aren't based on feelings alone, they require proof of intentional or extreme misconduct. A disappointing night out doesn't meet that standard. By the end of this, the courtroom feels less like a legal proceeding and more like a reality check. Drop a comment below if you think the judge handled this properly, or if you believe this case never should have made it past the filing window. Now, let's break down how this situation completely unraveled.
Quashante Short, QASHONTAE I'm sorry, I had to.
In the background.
I'm actually at the airport, so I had to go outside. It looks like they just departed the flight. They just arrived the flight. So I'm outside. It's a lot of people. It's a lot of people around. So I'm trying to go where there's no traffic. But thank you. That's okay. That's okay. No, I'm trying to finish this before I get finished. It's actually louder
okay. Here. I'm not sure. I read your complaint again, and you have not. I'm looking here. What is it? Intentional infliction of emotional distress?
Yes.
Is that the claim here?
Yes, okay. It is.
That's not something that's really justiciable in district court.
I'm sorry. I can't hear you.
I said that's not something that's justiciable in district court. That has to be brought in circuit court.
So you said it's not permissible in district court. It has to be taken to circuit court?
That's an equitable action, yes. Mm-hmm.
Okay, was that not I thought only criminal offenses. Well, I guess it would be considered. I don't know if it's criminal or however you want to consider it, but I thought only criminal offenses were brought before the circuit court. So will I have to?
What's in your head? I cannot get into what's in your head, man.
I'm sorry. I got to go back in because I can't hear you.
Mr. Jordan, let me just ask you this. Are you planning to represent yourself on this?
To be honest with you, sir, I thought this was just going to be thrown out. We had a date, one date, and nothing else after that. And now I'm being sued for $10,000. I don't see how this is going to go any further. I think it's a waste of your time.
The problem is this, if you think it should be dismissed, you need to file the appropriate motion. You need to file a motion to ask for that.
I will do that. I really didn't know what to expect. This is all new to me. I've never been sued before. I've never, gotten in any trouble. This was just, I don't know. But if that's the process I have to take, then that's what I'll do.
At first glance, this case feels unreal. Suing someone for 5 figures simply because a date didn't go well feels like something pulled straight out of satire. But here we are. One awkward meetup turns into a full-blown court appearance, and the defendant looks like he's still trying to figure out how his name ended up on a legal docket. The entire situation plays out like a chaotic chain reaction, one poor decision leading to another. And while we'll eventually address whether he made any mistakes of his own, what unfolds here barely resembles a standard civil dispute. It's tense, uncomfortable, and oddly surreal. To make things even more confusing, emotional distress lawsuits do exist in certain states, but the legal bar is incredibly high. Watching the defendant sit there, visibly overwhelmed, it's clear he just learned a very expensive lesson in how quickly personal conflicts can escalate when courts are involved.
There was also a perjury on there as well. He stated, I can't remember what he stated right now because I don't have it, the document
Perjury,
in front of.
the short,
Yes.
perjury is a criminal charge.
Okay, there were two different charges. There was one that was intentional affliction of pain, which was not. I didn't see that as being a criminal offense, but perjury, I guess that could be considered a criminal offense.
Ma'am, I'm not going to sit here and argue about the legal definition and what's a crime and what isn't. If somebody gets charged with perjury, that is a criminal felony charge. You have to go through the prosecuting attorney and the police. So that's what you are alleging.
Yes, the document will show that, and I also sent forth the messages where he was lying, and it proved he was lying. I emailed that to the courts. I wasn't able to print it out, but they didn't say anything as far as me not being able to turn those documents in. But that should have been in the case file as well.
Did you put it in there?
I emailed it.
I don't see that mentioned in your complaint.
Address.
No. If you are alleging a different count, you've got to amend your complaint to add it in. You can't. I don't know what you said you did, but you
the last time we spoke, the last time we were in court, I never changed anything. It's just that he was not properly served, so I had to get an address for him in order for him to be properly served. That's what was the last incident that transpired, was for me to get a correct address for him.
That has nothing to do with what I asked you about.
I know you asked me about an amended.
I asked you about what your claim is about. You said intentional infliction of harm, and I assume you mean intentional infliction of emotional distress. And you said perjury. That's the basis for your claim.
Yes, I'll amend the complaint. I thought I had that already in there. I received a document, I guess after I sent the correct address and he got the document, he sent a letter that should be, I guess, in the file. He sent a letter. And
that's
then
his answer, I guess. We're treating it as his answer.
Right. And so I emailed my response to that letter, because in that letter, he lied. And then that's what brought forth the perjury. It was never perjury in the beginning. It was perjury after his response.
Well, you can't say, listen, he has the right to put whatever is in the answer.
I'm not saying he can't, but
you can't add another count because you don't like or you disagree with what is in his answer.
If he responds and his response is a lie, it's perjury, then my documents will prove that he lied in his response.
No.
This is where the hearing completely loses structure. The plaintiff begins accusing the defendant of perjury, without understanding what the term actually means. He isn't under oath, yet she insists a crime has been committed, repeatedly throwing out legal accusations as if volume alone gives them weight. Even more shocking is her attempt to argue legal definitions directly with the judge. Think about that for a moment. Challenging the authority of the court while misunderstanding basic procedure is never a winning strategy. The energy in the room shifts from serious to chaotic almost instantly. What should be a focused legal discussion turns into a lesson on courtroom decorum. At this point, the hearing feels more like a live performance than a legal proceeding, and the judge is forced to repeatedly pull things back on track.
It's his version. First of all, do you understand what perjury is? I
Yes,
don't think
I
you even
said
understand what
perjury is
perjury
a
is.
lie. I
No, you
know what
don't. You
perjury
don't.
means.
Perjury is a statement, a false statement made under oath. So what statement
Exactly.
did he
And I
make under
got
oath that's
documents that
false?
prove he was lying.
You don't understand. What?
He
It's a false
he put a
statement made
document,
under
he
oath.
placed a
Under
document
oath.
that stated a
When did he
lie.
testify to something that he lied about? It's under
He,
statement made, a
he
false statement made under oath.
bottom line is you said it's a criminal offense, so I will send it to circuit court. Are we done here?
No, you don't understand, ma'am. You don't
Are we
understand.
done here? Are we done here?
Perjury
Are we done here?
is
I know
perjury
exactly what
is
perjury
a
means.
false
I know exactly
statement
what perjury
made
means.
under
I know
oath.
what perjury means. Are we done
No,
here?
you
Is it a
don't.
criminal offense or not?
What statement? I don't see anything in the complaint that says he made some false statement under oath.
Because you don't know what happened. You're on the outside looking in. You don't know anything.
But you're the plaintiff.
Put on
You
that
have, wait a
document.
minute, you are the
Are we
plaintiff.
done here?
You have to
Are we
lay
done
out
here?
your
Are we done
allegations
here?
properly.
Are we done here?
No,
I
we're
know
not.
exactly what perjury means.
No, we're
Do
not.
not insult my intelligence.
You have to
Please do not insult my
you have
intelligence.
to lay your you have to lay your
Please do
you
not
have to
insult my
lay
intelligence.
your complaint out. It has you have to allege this in the complaint. You have
Please
not.
do not insult my intelligence.
It's not about that. You don't think I don't think you understand what perjury is. It's a
Are we
false
done
statement
here?
made under
Are we
oath.
done here? Are we done here?
I
Please
said
do not
no.
insult my intelligence.
I said no.
Do not do that. Do not do that. Do not insult my intelligence as if I do not understand what the word perjury means. Do not. If it's a criminal offense, then it's a criminal offense.
Well, ma'am, it should not have been filed in district court if you want intentional infliction of emotional distress.
Okay, so that's a criminal offense.
Do you want? Are you going to dismiss it and refile it?
No,
in
I'm
circuit?
not. No, I'm not going to dismiss it. I will file another case in circuit. But as far as I'm concerned,
You can't have two cases on the ma'am. You can't have two cases going on the same issue.
Well, I'm not. I'm not dismissing the case. If you want to dismiss it, that's up to you. But I, as a plaintiff, am not dismissing the case.
He has to make a proper motion.
Well, that's on him.
But I can also transfer the venue to circuit.
Yes, that's what I thought, because there were other cases that should have been transferred somewhere else. So that's okay.
Okay, I'm going to do that. Ma'am, what about his costs associated with appearing because you filed it in the wrong court?
I need to see because I was not aware, since you said perjury was not on there, I was not aware that a criminal offense for intentional infliction of emotional distress was considered a criminal offense there, that it had to be.
I didn't say that. Forward. That is not what I said.
Yes,
that is not what I said. I said that. No, I didn't. You said that. Yes, you did.
You stated
I said that circuit.
You stated that the criminal. You stated that emotional infliction of emotional distress is a criminal offense.
From the defendant's perspective, this must feel completely unreal. One dinner date, one uncomfortable interaction, and suddenly he's sitting in a courtroom watching everything spiral out of control. You can almost see the moment he mentally replays every decision that led him here. The irony is hard to ignore. He appears calm, reserved, and cooperative, while the situation around him grows increasingly dramatic. It's not hard to imagine him wishing he could bill for the time lost alone. This case perfectly illustrates how quickly personal grievances can turn into legal nightmares. If nothing else, it's a reminder that not every conflict belongs in court, no matter how strongly someone feels about it.
And you stated that perjury is a criminal offense, but you also stated that perjury is not on the document that I placed forth before you. So criminal offense would not.
It's not in the complaint.
On there.
It's not in the complaint.
I need you to show me. I need you to show me the document which states that intentional infliction of emotional distress is indeed and in fact a criminal offense, because that's the original offense that was placed on there.
I never said that. I never said that.
Yes, you did.
I never said that.
Yes, you did.
No, I did not. Ma'am,
Yes, you did.
listen. I'm not going to sit here and go back and forth with you. I
I'm not
will
either.
repeat to you what I said.
I'm not either.
I
So
said
that's two
that
charges. So the
intentional.
charges have to.
You need to
As
be
far as I'm
quiet while
concerned,
I'm
the two
talking.
charges
You
have
need
to
to be
be
quiet.
separated.
Mute. Can you mute her, please?
Because perjury is a
Can you
criminal
please
offense.
mute
It
her?
has to go to circuit court.
That will not make her hear you, Judge.
Intentional
Well,
infliction
she's
of
got to be
emotional
muted.
distress.
What I said was intentional infliction of emotional distress is something that circuit court has jurisdiction over. I never characterized that as a criminal matter. It is definitely a civil claim, but it is something that can't be done in district court. Now, that's what I said to you. You are of the mistaken belief that circuit court does not hear civil matters because you said, well, I thought circuit court only did criminal. You are the one who are mistaken about the jurisdiction of circuit court because that's what you stated on the record. Unmuted.
She's been talking the entire time.
Well, I said I was muted.
Judge, excuse me, you don't understand how this works. Let me explain something to you about Zoom right quick.
Okay.
When I muted her and now I'm asking her to unmute, if she doesn't do something on her end, she's still muted. So right now she's still muted. But I have asked her to unmute. She's not looking at the device that she's holding.
Is there a website where I can get the forms I need for this to be dismissed?
Listen, sir. Let me just explain this to you. Okay? You know, there are forms of the State Court Administrative Office website. Okay? But, you know, if you don't know what you're doing, if you don't know what you're filling out, you know, you're just flopping around like a fish on a dock out of the water. And the same goes for Ms. Short, because she apparently doesn't understand the jurisdiction of what types of cases can be done in district court and what types of cases can be done in circuit. That's why we're having this issue right now. So, you know, look, how could I put it? If two people that have no military training are amateurs and they want to throw hand grenades, well, you know, if you don't do it the right way, you might blow yourself up. You might blow the other person up, but you might blow yourself up too. If they don't understand how the process works, I would say this to both parties. You need to seek out legal counsel.
The judge finally steps in with some clarity, advising both parties to seek proper legal counsel. It's a professional way of saying this situation has gone far off course. The defendant, while clearly unfamiliar with legal procedure, remains composed and respectful. That alone goes a long way. The plaintiff, however, appears to have filed claims without understanding jurisdiction, process, or standards of proof. Legal terms are being used loosely, almost as if hearing them once was enough to build a case. Meanwhile, the defendant sits there trying to follow along, nodding through concepts most people never encounter unless they've been through serious legal trouble before. The judge's patience here is notable, especially given how disorganized and misdirected the claims appear to be.
I can barely hear what you're saying. Like I said, I'm at the airport. There's a lot of people around.
Ma'am, are you getting ready to go on a trip or something?
No, I actually just came. I had a rental car.
Oh, I see. Ma'am, this is what I'm doing. I am ordering that this go to 7th Circuit Court. Venue is to be changed because intentional infliction of emotional distress is a circuit court matter outside the jurisdiction of district court. Plaintiff shall pay the filing fees in the receiving court. I don't know if you asked for a jury trial or not. You did not, it looks like. So there was no jury fee. No further proceedings shall be had after transfer until these costs or expenses are paid. If not paid within 56 days of the date of this order, this case shall be dismissed by the court to which it was transferred.
And what cost am I paying? Hold on. What cost am I paying for?
The filing fees for circuit court.
Why am I paying for filing fees for the circuit court? Because there's been multiple cases that have been brought forth.
Because you filed it in district court, we don't do intentional infliction of emotional distress cases.
Well, I need to see that in writing. I need to see that document in writing that states that
If you
you
want to
got that
appeal,
district
if you
court.
want to, if you want to
I've
appeal,
already skimmed SCAO. I've already skimmed that. I'm reading constantly every day, and I did not see that form on there
I'm
that
sure that
states.
you are. But if
Yes,
you
I
want,
am.
if you want to appeal my ruling, you got 21 days to do it.
Yep, I do.
You got 21 days to appeal it to the circuit court. My ruling. Thank you both.
By the time this hearing wraps up, it's hard not to feel mentally exhausted just watching it. The case is loud, confusing, and fueled more by emotion than law. Confidence without understanding can be persuasive to outsiders, but it doesn't hold up in a courtroom. Without an oath, there is no perjury. Without intent, there is no emotional distress claim. The judge remains remarkably patient throughout, but it's clear this case is hanging by a thread. Let me know in the comments, do you think the judge was too lenient, or handled this exactly right? Huge credit to the creator who surfaced this clip, check them out in the description. And if you enjoy courtroom breakdowns like this, make sure to like, subscribe, and come back tomorrow. We post daily, and I appreciate every one of you for watching.